Once a champion of COVID critics, lawyer Rocco Galati now faces a bombshell class action lawsuit where he's accused of pocketing millions while dishing out doomed legal advice, where Galati allegedly told desperate clients to ditch their unions and stay silent, leaving them with crushed cases and crippling court costs. From sloppy pleadings to recycled claims courts called bad beyond argument, this suit says Galati sold hope but delivered havoc. Now his ex-clients want their money back. A class action lawsuit has been initiated against once outspoken COVID critic lawyer Rocco Galati, his associated entities, and his Constitutional Rights Center, which I will refer to as the Galati defendants. The lawsuit alleges negligent misrepresentation, including pleading so poorly drafted they never had a chance of being heard on the merits. The bulk of this class action lawsuit centers on Galati's instruction to unionized members who were being ousted from their workplaces and effectively denied their ability to earn income due to COVID-19 related measures such as vaccine mandates. And it's being said that Galati advised them not to communicate or cooperate with their unions to file things like grievances. In addition to that, Galati reportedly advised his clients not to discuss their cases with other lawyers. And as outlined in previous decisions and according to the statement of claim, these actions resulted in some of these former clients being forced to pay up to $200,000 in court costs. The parties in this class action each gave Galati at least $1,000 and upwards of $3,500 in the case of once ousted Toronto paramedic Scarlett Martin, who, as the mother of 4, had previously been awarded the Exemplary Service Medal when she reached her 20th anniversary on the job. The broader class in the lawsuit is described as anyone who made payment to the Galati defendants or to the Constitutional Rights Center to initiate COVID-19 litigation between March 1st, 2020 and present. This is further broken down into 6 legal cases brought forward by Galati and or the Constitutional Rights Center, referred to as the 2020 Ontario Action, 2021 Ontario Action, 2022 Ontario Action, 2023 Ontario Action, the British Columbia Action, and the Federal Court Action. The case against Galati's actions explains that following the unprecedented state of emergency in March of 2020, Galati began representing himself as a constitutional expert and solicited donations through various fundraising campaigns to bring legal challenges to COVID-19 government measures, which is alleged to have totaled into the multi-millions. While people were losing their businesses and their livelihoods, Galati was making bank. It's outlined that the Galati defendants and the CRC promised to seek injunctions, declarations of invalidity, and constitutional challenges to government COVID-19 measures that would affect the rights of the general public, and that each of them had received in excess of $1 million to do so. The general theme of each action centers on an alleged pattern of ambitious but poorly executed challenges to government-imposed COVID-19 measures across multiple court jurisdictions. These lawsuits were brought on behalf of diverse plaintiffs ranging from individuals and healthcare workers to municipal employees, seeking declarations and injunctive relief against policies like vaccine mandates and masking requirements. Funded partly through public donations to the CRC and flat fee retainers, these cases consistently featured lengthy, argumentative pleadings that were said to have advanced pseudo-legal theories that had no reasonable chance of being heard by the courts on the merits, and violated various procedural rules, leading to repeated dismissals or strikes by courts for being prolix or bad beyond argument. A big part of these actions relates to similarly worded claims being reused by Galati even after others had been dismissed in other courts, such as the 2023 Ontario Action, which was deemed bad beyond argument 2 weeks before the closely mirrored federal action claim was brought forth, showing Galati ought to have known that the claim was doomed to fail. The 2022 BC action was deemed bad beyond argument as well, with the appeal being denied based on there being no reviewable error described and for, again, being prolix with a 391-page long notice of civil claim. The federal action was similarly deemed bad beyond argument for mostly the same reasons outlined in the 2022 BC action, but granted plaintiffs outside of the federal sector the ability to amend their claim. Instead of doing that, Galati filed an appeal of that decision, which ultimately found no reviewable error in the decision, but the judge did grant leave to amend to all plaintiffs should they wish to adjust the claim. I guess that's at their own expense. The 2024 Ontario action further found lack of jurisdiction, abusive process, no reasonable cause of action, improperly naming private citizens in a charter argument, which lacks jurisdiction, etc. The Galati defendants are further criticized in the statement of claim for inadequate client communication and advising unionized plaintiffs against working with their unions, which the Galati defendants should have known and in fact knew after that first decision that unionized employees have to at least initiate the grievance process through their union as their only legal avenue for employment disputes against their employer, and prioritizing ideological pursuits over client interests, often leaving plaintiffs liable for substantial costs and with little progress in their cases, as exemplified by stalled injunction efforts and a tendency to appeal rather than amend flawed pleadings at the judge's request. For the breach of contract claim, it was an expressed or implied term that the Galati defendants would do all things necessary or reasonable to protect or advance their clients' interests, draft pleadings in accordance with the applicable rules of the court, draft claims grounded in law, have reasonable knowledge of applicable or relevant law, follow basic civil procedural rules, name correct parties, and amend pleadings rather than appeal the orders striking the pleadings with leave to amend, which is much costlier, and do things like provide legal advice to the various risks of litigation. While none of these allegations have been proven in court as of yet, it is assumed that the competent legal team would likely have sufficient evidence to substantiate their statement of claim. Now, the plaintiffs are seeking a range of remedies, including an accounting and disgorgement of all revenue earned by the Galati defendants from drafting pleadings and pursuing appeals in these various actions. They also claim general damages estimated at $4 million, special damages at $1 million, and aggravated or punitive damages at another $1 million, with all amounts subject to proof at trial. When Galati was contacted for his comment on the filings against him, his counsel responded that he intends to defend against this baseless claim. Mr. Galati and Rocco Galati Law Firm Professional Corporation are represented by Ken Fitz at McLennan Ross, whereas the Constitutional Rights Center Inc. is represented by Joe Spelsey at Duncan Craig LLP. Although Galati has attempted to sue those who criticized his legal actions previously, the courts dismissed his 2024 case under anti-SLAPP legislation and ordered him to pay $132,000 in costs. Galati's former client, Dr. Kalvinder Gill, is suing him for $2 million, and Canuck Law has the receipts. Damages include professional negligence, breach of fiduciary duty, and or breach of contract, pain, suffering, loss of reputation, as well as aggravated and or punitive damages. Another former client, Dr. Ashvinder Lamba, is suing for similar damages in the amount of $600,000. Now, this particular class action suit could very well lay bare an alleged betrayal of trust, masquerading as a crusade for justice that lured desperate Canadians, mothers like Scarlett Martin, healthcare workers, and municipal employees into a legal abyss with promises of bold challenges to COVID-19 measures that never came to fruition, despite amassing millions through retainers and public donations. Though the claim advances things like negligence, many are left overall feeling exploited during a time of crisis when they needed assurance the most because they were poised to lose everything for speaking out against the illusion of consensus when it came to the handling of COVID-19. For Rebel News, I'm Tamara Ugolini. If you would like to support our work and this kind of journalism, you can do so by sporting some sassy swag from the Rebel News Store. Head on over to rebelnewsstore.com to check out all of our latest and greatest designs and use code TAMARA10, that's TAMARA, number 10, at checkout to save 10% off of your total order. That's rebelnewsstore.com, code TAMARA10 for 10% off at checkout. Thanks so much for your support.